In this video we want to talk about the Equality Act of 2010. Now this applies to the UK, but other countries are enacting similar pieces of legislation. The purpose of the class is to illustrate the way in which the legal framework is evolving to cover areas of discrimination, unfairness and more equality within the workplace. So it's important to see what the legal framework is, as well as the more enlightened practices that are being put into place throughout industry and commerce. The need for vigilance in this area is ever present. It's important that the legal framework is up to date with current thinking and is based on accurate research and understanding of the needs both of the workers and of industry. So the Act, as I say, came into play in 2010. It's introduced to improve working conditions and equal opportunities for employees. Sometimes leaving it to market forces or leaving it to industries to sort out equitable solutions is either too slow or simply will not happen. It gets put onto the proverbial back boiler. It's put off for another time, and that's not fair to the workers. That's not fair to job applicants. So sometimes it's necessary to preempt what may happen and introduce legislation to prevent injustice occurring and to ensure that there is fairness right throughout the system and that is legally supported. In an ideal world, of course, there will be no need for this legislation. We don't live in an ideal world, and that is the problem. So it was felt that this type of legislation was important, and it was important so that workers would not be discriminated against on the basis of gender, race, age and so on. We'll look at the various ways in which people can be discriminated against. But it was felt that some legal status was required to support workers in their bids to earn a living. Organisations must implement policies and procedures to prevent discrimination. So organisations must be vigilant to ensure that their practices are not discriminatory. It's important that all applicants are treated equally. They should be treated on the basis of merit, perhaps looked at in terms of qualifications and experience and issues which are germane to the particular job or to the particular requirements of the position that's advertised, but not based on characteristics such as race or religion or orientation, perhaps sexual orientation or colour of skin. These are not the basis upon which commercial decisions should be made. So it was felt that the legislation was appropriate. The Equality Act came into effect in 2010 and aimed to harmonise discrimination laws. In fact, in the UK there was quite a wide range of discrimination laws, and it was felt that one consolidating act would be better to bring all the various parts together into one act, and this became the Equality Act of 2010. So it brought together over 116 pieces of legislation. So it was quite diverse legislation. It appeared in many different laws, but the Equality Act updated it and brought it all together into one act. So it's easier in a sense to know our rights and to understand the legal framework in the context of discrimination. The Act makes it unlawful to discriminate on grounds of what's termed as protected characteristics. Now, protected characteristics are age, so people should not be discriminated against because of their age, disability, gender reassignment, marriage and civil partnerships, pregnancy and maternity, race, religious belief, on their gender, or on their sexual orientation. So there are various protected characteristics that the Act attempts to remove the possibility of discrimination. It tries to at least get rid of overt discrimination. Removing covert discrimination might be far more difficult, and that may be the subject of other classes. But at least in those areas, companies and organizations cannot discriminate against applicants. The Act combined various anti-discrimination laws. The purpose is to make the law easier to understand and offer greater transparency. So it brought together pieces of legislation from other acts, other clauses in different acts. It brought it all together into one act, so it's easy for us to know what the source of the legislation is. It's the Equality Act 2010. We don't have to go digging into the legal framework and trying to find out where particular laws are and so on. So it becomes clear. There is one act that covers it. It protects individuals from discrimination in employment, in educational institutions, as a customer, when using public services, and in renting property. So it tries to protect individuals from discrimination in various ways. When they apply for work, that they shouldn't be discriminated against in the various ways as we've outlined earlier. In educational institutions, they should not be discriminated against on the basis of those characteristics either. Or as a customer, they can't be refused access to shops or to areas on the basis of the characteristics. When using public services, or renting property. The main legislation that have merged due to the Act, well, as I said, it came from a wide variety of acts in the past, and it was updated in this particular Act. But the main acts in the past that were affected were the Equality Pay Act. As you can see, it goes back quite a way. The Sex Discrimination Act, the Race Relations Act, the Disability Discrimination Act, the Employment Equality Regulations, and the Equality Act of 2006. So the new Act consolidated all of those. It brought them all together into one new Act. So it makes it easier to know our rights. We just have to consult the one Act, and that gives the law on discrimination. Now, for complaint procedures under the Act, well, an individual has the right to complain to the Employment Tribunal if they feel they have been discriminated against. So employment tribunals exist, and if a person feels that they have been discriminated against, they can bring an action in front of a tribunal, and the tribunal will hear the case. It's very similar to a court of law, except it's a small scale in the sense that it's easier to access, it's cheaper, and it's open to people to use, so that they can air a grievance and have it heard by a panel who will decide whether there is merit in the case or not. The complaint must be made within 3 months of the alleged offence, and a case must be put forward to a tribunal hearing. So there is a timescale. When an issue arises, it should be dealt with within that timescale. Otherwise, people would hark back for many years, and people's memories fade and documentation is lost and so on. So it's best to bring it to a head within a short time scale. Now, the tribunal, employment tribunal, has the power to award orders claiming the right of both parties. So the tribunal can define the rights of both parties. It can look at the circumstances of an allegation or of a case and can then issue what it considers to be the rights of each of the parties, perhaps the employer and the employee, and can indicate what the course of action should be. It can look at discrimination. If there's an issue of discrimination, then it can take that into account. The discrimination will have to be proven. There will have to be some sort of evidence of discrimination. It can't just simply be an allegation. It must be supported. The employer may have to pay compensatory damages if the ruling goes against the employer. So the employer must be careful to ensure that his or her practices within the business are clean and open and non-discriminatory. Otherwise, they may be liable for damages at a tribunal hearing. So that's the basis of the Equality Act 2010 in the UK. It's worth knowing because this framework may apply in other countries, and other jurisdictions may pick parts of this legislation and integrate it into their own laws. That's common practice in terms of legal procedures. But that's all we're going to deal with in this session, so let's leave it at that. There are some readings on the Act that were used, but let's leave it at that and say thank you for watching.